When we come to property settlement now, the big issue here will be your needs, your contribution. So there are different weights. We're looking at different factors to a large extent. And yes, the court will consider behavior, but it must be behavior that is gross and obvious. So,
Okay.
and gross and obvious is not what you think. It must be something like after the divorce, he sold the house, burned down the house, sold the business for less than the value.
Right.
Definitely unconscionable behavior. But you cannot use domestic violence that you have already used for your divorce to now use it as a ground for your property settlement.
Settlement.
The
I
larger
think
issue in property
you
settlement is contribution.
I think that's a beautiful and very, very important point, Avian, because oftentimes the average person may be very confused about what facts contribute to what. And oftentimes it is assumed that property settlement is part and parcel with the divorce itself and just another part, right?
And
But
this is why the first thing the judges do
mhm,
is separate the parties.
yes,
And they can take all of 5 minutes to get a decree nisi.
correct.
However, thereafter, you go into the long story of property settlement, beginning with valuation, beginning with affidavits,
Yes,
exhibits, receipts, documents,
and this
and
is
now,
why
of
we
course,
ask,
all parties, conferences,
right?
meetings, site visits, etc.
Negotiations.
And then to come to close to what could be the real value of each person's contribution.
Uh-huh.
And that normally takes, so while your divorce happens in, let's say, 5 to 10 minutes, property settlement takes at least 1 year.
Yes. And I like that we're able to, and I want us to stick on that point to really reiterate that they are different and that you can very well already get even your decree absolute and still be dealing with your property settlement because they are considered two different matters essentially. And you cannot, so interesting, rely on the fact that you relied to end your marriage. It is not necessarily same facts that can be used to verify or justify your share in the property.
Right? But an important point to note is that you will hear the judges say they will reserve your rights under Richards and Richards. That's a very, very important clause.
So if you could
And what
repeat that, often the judge will say too.
the judge will say, your rights are reserved under Richards and Richards. Of course, Richards and Richards is a case. And what the judge is saying to you there is that based on the particulars you have given in your divorce petition, you are free to return to those particulars to help bolster your application at the other level.
Right.
Yeah?
Yes. But it
And
would
this
be
is
as a
why,
support. It's not the substantive
that's correct.
claim.
And this is
Yes.
why some people do a cross petition,
Right.
particularly where in the petition of the spouse, let's say spouse A says that when I married him, he came to live with me at my mother's home. And that house, that property is owned by me and my mother. And my husband and I lived in my mother's home
Right.
all our lives. When we come to property settlement now, and he wants his share in the property, you're allowed to go back to that fact because you notice that is a property issue that you would have pleaded in your divorce petition that has a bearing now on
On
your,
your property
yeah.
settlement. Love it. I love it. So, for those now joining us, we are discussing matters as relates more specifically to property settlement and divorce. We're just reviewing some of the questions that we had last week. And Mrs. Joseph, so eloquently as usual, is really explaining the importance and the difference with your petition application itself, and the difference between the divorce and those decrees that are granted. First, the decree 𝗧𝗵𝗲 or 𝗧𝗵𝗲, some people say 𝗧𝗵𝗲,
Yeah.
and then the absolute, and then the matter then of property settlement. All
But
right.
let me just say something on absolute that
Sure.
is very, very important.
Mm-hmm.
So when you get a decree 𝗧𝗵𝗲 or decree 𝗧𝗵𝗲, I say 𝗧𝗵𝗲.
Yes, me
The
too.
decree 𝗧𝗵𝗲, like this, generally on first hearing,
Right.
you are not divorced. People are, you know,
Confused with that.
uncertain about that, and they think they are divorced.
Yes.
Unfortunately, if your spouse dies before the decree absolute is granted, you
Okay.
are still married. The other interesting thing there, you will hear when the judge pronounced decree 𝗧𝗵𝗲, he or she goes on to say not to be made absolute before 6 weeks. And
Yes.
6 weeks is 44 days. So when you count 44 days, you would think you are now ready for the decree absolute and you're now divorced, as happened with another client of mine. I said, that is a normal thing the judge has to say.
Yeah.
Because during those 6 weeks, you could settle everything related to the children,
Right.
if there are children in the marriage. And if the issues concerning the children are settled within the remaining, the ensuing 44 days, well, then you now apply for your decree absolute. If there
Mm-hmm.
are children, minor children in that marriage, and we are still quibbling over maintenance and custody and access, you cannot apply for your decree absolute. In other words, you cannot get your decree absolute until the court is satisfied that the arrangements for the children are satisfactory.
Mm. Very.
However, you can get a decree absolute, apply for a decree absolute within the 44 days if there are no children and there are no issues with children to be sorted out. And the other thing is, even when you apply, until that document has been issued to you, you are still married. Very, very, very important. And if more than a year has passed and you have not filed for your decree absolute, you have to do an application to the court explaining the reason for your delay.
Yes.
And you have to be able to tell the court that you did not resume cohabitation. It's very, very serious.
Some critical points there, Vivian, and I see your passion and vigor for it, because I know that you're probably thinking about cases and matters in the past that you have seen this influence and affect. And I will give my little story of one because I never forgot this. But even before I do that, I just wanted to reiterate for those now joining us, because I'm seeing more persons joining, coming on new, just a sort of review. We're just recapping issues as relates to divorce and really explaining thoroughly your understanding of the implications to the same. We have touched on the fact that property settlement and divorce will be dealt with by the court as essentially two different matters, and one does not necessarily solely rely on the other. However, you can depend or rely on your petition or your application for divorce to bolster your facts for your
The
property settlement.
particulars you would have used.
The particulars, yes. Additionally, we would have also indicated that, and I think it's very important, a decree 𝗧𝗵𝗲 does not mean that you are divorced, and you are still required to apply for your divorce to be made absolute, your decree absolute. All right. And as Ms. Joseph would have highlighted, there are several matters and considerations, especially if there are children to the marriage, that the court would like you to settle before being even eligible to apply for the absolute. And more than that, you are still married. So, Ms. Joseph, talking about still married with 𝗧𝗵𝗲, I remember a matter my mother had, because she primarily did a lot of probates, and uh, the deceased man got, well, his then common law wife thought that he was divorced, but in an investigation they only had the 𝗧𝗵𝗲. No one ever applied for an absolute, and he died intestate.
Wow.
Yes.
I like
And
that matter.
you like that? More interestingly, the common law wife was new. He did not live with her for extended period of time. It was a new
Right.
romance.
But you see this, I like how you raised that there. And this
Yes.
is why, without knocking anybody's faith or so,
Hmm.
there are, as you well know, there are religions that do not allow you to be
Yes.
divorced unless
Yes.
there is adultery.
Correct.
So, what I say to those parties, rather than just going your separate ways, the court allows for what is called a judicial separation.
Mm.
So, you separate the properties and all of those issues so that when one party dies, you're not the other one cannot walk in and claim XYZ because you would have
Correct.
dealt with those issues. You remain married, but you're
Yes.
judicially separated.
Separated. Yes. Very,
So that's
very
an avenue given to persons who do not believe.
in
I do
divorce.
not believe in divorce either.
Yes. Neither do
But
I.
exactly. So it's not a question about believe in it.
Correct.
I prefer to say I do not lightly use the avenue.
Hmm.
You need to be aware of that. Is an avenue given to us in the court system to deal with
Yes.
certain family issues.
Judicial separation.
So it's not a question about I believe, I don't believe. It's not something for me to believe in anyhow.